as we initiate chaos theory guarantees that we'll play like lightning shots sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All above the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
You guys, the judge does not look happy. Judge Kent, he of Real Genius, looks pissed. And perusing through the general law and crime chat, it is not going well for now. They call her Snooky, which appropriate. It is not going well for Kim K. So we are just going to get into this, but apparently the judge is pissed. We do not have closed captions on, so let's go.
Answer yes. Question, and what time was that? Answer 10:26 in the morning. Question, okay, now what kind of phone does your Aunt Jennifer, what kind of phone did your Aunt Jennifer have? Answer, she had an iPhone. Question, and do you still have that text message in your phone today? Answer, yes. And did you look at that text message recently in the last day or two? Answer, yes. Question, now prior to the last day or two, when was the last time you looked at that text message? Answer, the day I sent it, November 20th, 2018. Question, so you haven't looked at the message since? Answer, no. Question, when you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question, or excuse me, answer.
So basically, if you weren't here at the end of the day, and I did kind of skip through it, again, as much as Paul's family has really gotten underneath my skin with some of their little things that are just big bugbears to me, I did not want to be just vicious to a pregnant woman who, despite her attitude, is at some level a victim of Paul's. So I recognized that there was no way we were going to get through her testimony without me losing my general ish. So basically, what the defense tried to get in were text messages and other things that were sent by Katie. Now, that shouldn't be a problem, except that this was never noticed to the state. Now, I'm not a lawyer or anything, but I do know that there are certain procedures that the state has to go through as far as discovery. But I do believe that the defense did a very big misstep here in trying to do a trial by ambush. So I will be interested to see. Sorry, I'm like, ooh, I'm getting too hot. I don't know how Kim K sits in those jackets. Although she's probably not perimenopausal, so there you go. She's not having hot flashes. That's how she can always wear a jacket. I go from I'm freezing to, oh, let's see here. Mr. Mo is like, I'm going to be up near Sam's Club. Do you want anything? And I'm like, gummy nerds. Nerds. Yes. So there you go. But that's basically the reason that we are here for this hearing. This is outside of the jury's purview. So they are not hearing this. But again, kind of cruising through law and crime, the judge is going to get irritated because Kim K, again, with her startling inability to read a room, is going to start being disrespectful to the judge, like a flippin' flapjack moron.
It's an iMessage, and it changed from delivered to read. Question, okay, so do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer, no, I didn't look at it for 7 years.
So basically, what the defense is trying to bring in is that someone, and we don't know who, but in theory, probably the police, were able to activate Jennifer's phone and look at the text message that Katie sent 2 days after or a day after she died. It, yeah.
Question. Now, the fact that it said red, did that stand out to you? Answer, yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Caitlin Caneiro. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was when you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at side.
Kim K, look, I am trying to help you, but you need to work on your posture. You are going to develop a hump in your 40s. And don't say I didn't tell you, because I warned you, shoulders back, head up, support with your core. I can't help you any more than that, and I don't feel that I'm obligated to draw this out in crown. So
Sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that.
I don't know who needs to hear this, Kim K, but what is the golden rule of practicing law? Well, it is don't piss off the judge. Now, what you have done here is piss off the judge, who has already been, again, collecting the very last little bit of Jesus. As a fellow parent, I can see a fellow person who is having to deal with an adult toddler, and he's that one little bit away from starting a Snapped episode, and I done tried to warn you. Like we all said, really think about yourself. Go home, take this weekend. You and Ponytail collect the 2 brain cells you have together, rub them, get something and rethink your entire idea. But you were just like, we are going to quadruple down on the stupid. It's a bold strategy. Let's see how it goes for them.
I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this. I've reviewed the state's brief, which I received somewhere around 8 o'clock last night. It was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual 2 items of evidence, both being what was testified to and would be stored within the witness's phone to include the actual text message that was marked red and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion, which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really,
so again, while these sort of surprise tactics work really well in a, legal procedural drama, courts are very much not fans of not knowing things, because generally there are statutes and different things that they have to research, and they like to be aware. They like to be as prepared as they can be to make a decision. So especially with again, the defense was not able to read that this judge appreciates accuracy, transparency. He is very, very detail oriented. The biggest way to piss this judge off is to be ill prepared or, have stupidly thought out arguments. And yet this defense has been continuously picking his buttons all trial. And now they're trying to pull their biggest thing here. And again, if this was something that, Corey took the iPad, again, nothing in the investigation. Okay, again, you're saying that Paul isn't a moron, but Corey is a evil genius on the level of, oh gosh, I don't know. I'm trying to think of a very Osmandius. Almost. He's omnipresent. He has Dexter-like abilities to not leave any DNA or any signs leading back to him. He was able to get, Paul's DNA into the gloves, not leave any of his own, which I don't know. Did he steal some of Paul's old gloves, but have a glove on before he put on? It's just too nonsensical.
Really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the state, which it never was. And because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response.
Holy shit, defense, you seriously waited till 10 o'clock last night? Again, let me explain to you. And I realize that not everyone processes these things like I do. This is much more of a people watcher kind of thing. But right off the bat, in just being in this trial, I can tell that this judge doesn't like the last minuteness of this defense. He has, been very unimpressed with them, and he very much likes competence. He appreciates competence. He doesn't care in what form it comes, from whom or wherever. What he really what really pisses him off is when your incompetence becomes an actual, actually disrespectful to the court. And that's what it is about. This is about where your disrespect gets to the level where she might be looking at sanctions.
And the defense's response, for the first time, defense counsel admits that she had an actual screenshot of the phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour, and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence.
Which means that he's a grieving family member asking for things. Maybe, again, in days before, maybe he would have picked out a magazine or a book or some toys. But I can tell you, as a parent who even tries to limit screen times, a lot of my kiddos' lives, like their friendships, their Roblox, their interactions, what they're into, is all wrapped up in their tablet. So again, you can very much see the single note, very lazy narrative that the defense is trying to create. But you could just as easily argue an opposite and absolutely normal way to look at this. Yeah, yeah. She decided to piss off the judge. I don't know. Yeah, there are so many plausible alibis. Again, the only thing implausible is that Corey was able to manufacture all this conspiracy at 2 different crime scenes and leave nothing of himself behind. That's the impossibility. Yeah, I don't know. I mean, like, you're not thinking rationally. Again, we saw this in the Theodore Edgecombe case where the defense in you know what? That might be a poll. Was B. Ivory Lamar's defense more offensive or this one? Well, now they're claiming that the iPad is the definitive evidence, and the only thing, again, that has ever linked Corey is the fact that he was one half of the contingency beneficiaries. So if I were the defense, and I know they're probably not going to do this, but if they wanted to fix this, they would humbly tell the judge, we'd like to withdraw this witness. I think this witness is, from the majority of people, do not think she came across optically well. Now, there are some people that are willing to extend her grace, but I would throw the baby out with the bathwater, pun intended at this point, with that witness. Whatever sympathy points, whatever happy points that you were, or, things you were going to get with this witness, it's not going the way you think. It is less than 10% of people that really have any grace to give to this woman. And even then, they're like, yeah, it's not a good look. Like, even the people that are supporting Katie's sort of testimony are still trying to justify it by various means. And I get it. I totally get it. But if their defense were smart, they would apologize, they would grovel, and they would say, Judge, we humbly would like to withdraw this witness. Now, they're not going to do that, but that would be my non-lawyer advice.
About that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble. But of course, this was dealing with when Vogt collected the DNA samples in 2020, not in 2018. Second, the state argues that it demonstrates that this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out,
Major Mom, That's a fair question. So I kind of have been, I kind of just ruminate on things. I know it sounds really weird, but that's kind of one of the fun things I do. It's like my own video game, or oh, how do women with long hair deal with this? I'm sorry, but wigs are ridiculous. If you're not used to having really long hair and then you're trying to move around, I know, problems. But, so I did wonder about that because it would seem to be the easiest way to, blow a hole in this defense. However, I think that the state, and again, going above and beyond, being respectful and actually treating Corey as a separate but just as affected victim, they if it's possible to win this case without having Corey have to come up and testify, have to face his brother, have to face all the trauma, I think the state is doing everything they can so they don't have to do this. I mean, I can't imagine what Corey has gone through to lose his one brother to the most heinous act ever, an entire family, and then to, in your heart, probably know that your other brother did it. My guess is that the state doesn't want to cause anymore, and quite honestly, they don't need him. It's remarkably insane to think that Corey could have done all this and leave no trace. So it,
I want
that might be total random speculation, but that has been one logical avenue that I've kind of figured the state was going with. I'm sure they did tell him about the potentiality of maybe bringing him on rebuttal, but I'm guessing again, this has been this is a family against a family. You've got Paul's family that's definitely on the defense side, and you've got Corey. And again, if you can do this case, which I think the state can, without calling him up, I wouldn't. He's a wild card. You don't know if you're going to get an outburst like in the Letitia Stout trial that I think was incredibly powerful, but I can imagine cost Letitia's brother a lot to have to go up and testify in front of his sister. So I think that we are incredibly lucky that an older, seasoned, mature, and very, very professional state attorneys, two state attorneys, took care of this case because I think that in a younger, less confident, DA or DAs, they might have brought Corey on, but I think because they were so comfortable with the thoroughness of their investigation, they have him in their back pocket, but they know pretty much the defense cannot call him. Cannot. It would be ridiculous. So they're kind of calling the defense's bluff. Like, we can win, and it might be partially psychological. We can win without Corey. We think so little of your defense. We think so little that we are not even going to obviously block this. And I bet that pissed off Kim K. She has seemed rattled and off her game this entire time. And I think that maybe that might have been the dynamic that we've seen here. She was expecting, the state to go ham about Corey, and the state's been so competent. She sees everything through her own personal lens, so she is shocked that other people can be competent at their job. This is just my armchair psychology feel about it, but I think it might have been several parts of one, half a dozen of other, and maybe there were other things going on. But that's my thoughts about why they didn't.
I want to go back for a minute to the text message. There was one thing I did want to add to that. In the submission, no, I don't need to go back. In the submission, it also points out that that when Katie learns of the location in February of 2019, that she sees that the location was at Corey's house. There's a footnote that the defense counsel talks about, which says it should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it either via text or phone.
Okay, wait. Yeah, because I'm just realizing something, and and the defense doesn't realize, and Katie doesn't realize how fucking bad it is once you logic this shit out. Okay, stick with me, y'all. Okay, Katie found out who really done it, but was so pissed off about not being able to go take a shower after being, interrogated by about a fucking obviously suspicious fire. Look, y'all, I am not going to be able to keep this curse free. That she was so pissed off at the state for, not letting her, take a shower and giving her an emotional support cuddle buddy, that she didn't share valuable evidence about who might have actually killed 4 people with the state because she didn't trust them with the evidence. Do you understand how absolutely terrible that makes you look? Like you had the cold fusion thing from Fallout and you just decided to stick it up your bum for no reason, tell no one. I mean, it is that old gag from The Grinch that stole Christmas. Cure the world's diseases, tell no one. No, I am pretending to be Kim K, but I put it on the wrong side. Also, I don't have a straight black wig, which I thought I did, but apparently I don't. I do need to work on my futuristic labeling thing that I've been meaning to do for the last 6 months. Welcome to ADHD. I'm definitely good at planning things. The execution, not so great. In my head, I am already organized though, because as soon as I get it, I'm going to do it. Look, I'm having a hard enough time stretching my imagination to imagine them as lawyers, let alone prosecutors. I could imagine them playing on the CW in like the Archerverse or Archie, where they made Archie and Veronica, well, basically everyone big whores. CW, stop making Sabrina the Teenage Witch. I thought they were remaking that and that would be awesome. No, it's nothing but hoology. I'm like, good night. Stop taking everything from my childhood and orgifying it. Let's get back to this stupid. I want the judge to lose his mind.
Once she saw it, that he had the location and asked him why he had taken Jesse's iPad. That is the first time and only time that the court is aware of that either there is a documentation in a phone of either a text message or a phone call in Caitlin Canero's phone that could corroborate or provide information that could be investigated.
Ma'am, who are you looking for? Ponytail Tristan III is not going to stand by your side. Those white knights, those male feminists, if they're not the ones that are doing the bad stuff, they are not going to stick by your side. You have only yourself to blame, you strong, independent woman. Hear you roar, then you need to take the accountability for trying to do some stupid BS like this.
Investigated as it relates to the issue of whether that occurred or not. That either text message or phone call was not turned over to the state, and if it was turned over, they can tell me when they start to argue. I should point out that the defense is, in saying everything that I've summarized so far, the defense is saying that they are not suggesting that the iPad was taken at the time of the murders, as it was clearly depicted during the testimony of the forensics detective when he went through the evidence found in the kitchen, where there was an iPad located there.
And welcome, Broken Baker Raiders. Just for a quick visual about where the defense is trying to take their narrative, they have tried to sneak in a hitherto never known fact that Corey, the only surviving brother not accused of, well, killing people, After the scene was cleared at Keith Canero's house, did take Jesse's iPad, which would have been turned over to him after there was no relative evidence found on it, I'm guessing. Now, the defense decided that it was okay to hide this because reasons. Now, this is only now coming out, and they're not using this evidence that they hid to suggest that Corey took it the night of the red rums. Now, the defense's entire case has been that Corey Caneiro, yes, the brother who has no DNA or trace evidence links to either of the two scenes, was somehow able to conspirosity more than everyone in LA did before to O.J. Simpson, and was able to not only do a quadruple homicide, but count them, two arsons across town from each other and leave no DNA evidence behind. In fact, he was so skilled that he was able to get Paul's DNA on the inside of some nitrile gloves and his niece's blood on the outside. Or it could be the fact that nothing in this extensively investigated case ever connected to Corey. We had a DNA expert yesterday who, like Dr. Spiegel, may make you no longer, believe in psychology, but also believe in DNA, the way he was testifying. So the defense has been a slow-moving train wreck, and now the judge is going to lose his mind on Kim K. So I am dressed as her today. Because I figured maybe I could understand where her moronic behind is going. Maybe if I cosplayed as her, I could be as dumb as her and then explain it to you guys. I could be the translator between stupid and normal brain functions. He is 2 minutes away from Bobby Knight. He has held it together for 16 damn days. He is trying. He is so trying.
The iPad, I guess, based upon what defense counsel is saying, is that the iPad that's located in the kitchen is actually Jesse's iPad. I don't know if that was clear during the testimony at all, that somebody said specifically that they knew that it was Jesse's iPad, but that also is something that's being argued. But what the defense is saying, that they were trying to be careful to make clear to the jury that Katie saw the location in February 2019, a few months later, so not to be misleading. However, there was no context to this as to when, at that point in time, how long that the location was at Corey Canero's house for this iPad. It truly was unclear because we didn't get that far based upon where we were. Defense counsel further argues that the state had full access to Susan, Katie, and Marissa, that the state had the ability to interview them just as much as the defense did. However, what's interesting to note about that is that it's clear from this submission, and it's noted specifically as a footnote number 3 on page 4 of the defense's submission, that the defense was aware that the state was making efforts to speak with Susan and to Katie and Marissa close to the time of trial to make a decision on whether probably if they were going to call them or not. However, that none of them were willing to speak. So the state did not really have access to them. So when it comes to the defense putting in their submission that for the weeks during the course of the beginning of this trial, that they were not sure if the state was going to call the...
This is the other part of the problem. The defense basically shared with the court and in the presence of the jury that the entire Paul Caneiro family felt disrespected and like their civil rights had been violated at the police station, that their statements were coerced from them in exchange for them to be able to leave the police station while they were under protective custody, because the police were not sure why 2 houses with people named Caneiro were being torched in a single day. They were a little confused. So, uh, but basically, Paul Caneiro's family has refused to cooperate at any level with the state. Basically, the defense was the only one privy to talking to these particular witnesses, and then did not share anything that they had learned.
Either Susan, Katie, or Marissa, court has some level of concern of that statement based upon the fact if the state had no idea what these individuals were going to say, why would they call a witness that they have no idea what's going to come out of their mouths other than a statement that was given 7 years ago, but now they're unwilling to speak to the prosecutors. So I'll leave that for another day, or for the state to deal with if there's something that should be added. I'll point out that while the state did have Susan, Katie, and Marissa are on their witness list, the witness list is a list of people that may be called. It's not every. It's more people that are ever involved in a case. The witness list is used not just for the potential witnesses, but it's also for the jury to know, to be read each individual's name, so that if one of the jurors happens to know one of these individuals that may not be called as a witness, it's still important for the court to question those particular jurors as it relates to that issue, on whether that if they knew that person, even if they're not being called, would that have impact their ability to be fair and impartial? So the fact that the Susan, Katie, and Marissa were on the state's witness list is of no moment to this court as it relates to them being there, and as to whether that there was an obligation here to turn over this type of evidence. I also want to point out that counsel brings up the fact that, well, this trial is moving exceedingly fast. I just want to say that I've disagreed with that from the door. I gave the March 20th.
Thank you, Jesus. This judge is like, no, it would have gone faster if you hadn't been functionally stupid. I blame you for every delay in this trial. Yes, tell her, judge. Tell her, explain how her ineptitude has hurt us all. Oh gosh, talk petty to me, judge. Judge, we would like to award you the St. Bertha Smartass Award. We salute you.
Date, because everybody indicated that that's how long the trial would be. It was never what the court thought how long this trial was going to take. As the trial went on, it was clear that this case was moving quickly. As early as the first week, it was clear that this case was not going to take as long as what.
Oh my God, is Kim K trying to say, like, judge, so, like, your honor-ness, so what had happened, like, I seriously was gonna do all of the research. I was totally gonna do that, and I was manifesting, like, an energy because, with Mars being in retrograde and me being a Sagittarius, it was, like, really hard to find, motivation, but I had my tarotologist look, and my birth chart said that, like, the next 2 weeks were gonna be really super-de-duper productive, but I just had to manifest and kind of sit in this anxiety to really, sharpen my spirit, and then, so I really just planned to do, like, my discovery and stuff then, and then everything started going really fast, even though we tried to ask the most asinine questions because I was trying to slow it down, because it's very important to listen to the universe, and when your astrologer says that you're gonna be really productive, then that's when you do your work. The end. Well, post-punk, he might like it. I'm having fun pretending to be her, because as much as I tried to parody that out, I almost I almost can't go to parody because she's probably gonna make that argument. This is I feel like the writers at The Onion and the Babylon Bee, like, how am I supposed to parody things? Half the things I say turn out to be reality, and I was just bullshitting, you know?
Was being said of March 20th. So I don't find that the movement of the case in an expeditious way was any surprise to any of the parties as we move forward as to when the prep of Katie was done, or how ultimately we come to the conclusion of where we are today. So defense also talks about state versus tier, and I'll get into that when I give my ultimate decision. And lastly, the state says that it doesn't believe that it violated any reciprocal discovery, but if it did, that it should be a brief continuance instead of a violation that bars the actual testimony. And there was 2 exhibits that were supplied with the defense's submission, which includes, again, a photograph. In Exhibit A was a photograph of the kitchen area where the defense is indicating that Jesse's iPad was located on there.
Well, and also, there are so many. The more you dig into this piece of evidence, the more you realize that it is so bad. So how are we going to lay foundation that this iPad, because anyone can change any whatever to say whatever pad, how are you going to authenticate from a screenshot that was in fact Jesse's pad? The more I think about this, the more it gets worse and worse. Jesus, Kim K. This is the reason that when Mr. Mo brings up that I could go to paralegal or law school, I'm like, yeah, but instead I'm able to come up with all of this on my own and I don't have to go back to school. Yeah, it's more that I'm just lazy. Let's be real.
And then, again, that's what the defense is saying. And then second was the actual screenshot that was never turned over. I summarize what people have said so that we don't need to reiterate the actual arguments. However, considering that the state submitted their submission before the defense, I don't know if there was something else that they wanted to respond to, but I'm going to allow both sides to create their record before the court makes its ultimate determination. I'll start with the state.
Thank you, Judge. Now, I just want to start off by saying that I think that the court's summary with respect to the issue that came up yesterday and the court's summary of what was stated in the briefs is spot on. I mean, I think that the court essentially hit every point that the state would have argued. Obviously, the state and the defense in any case have different discovery obligations. We're all aware of that. But that does not mean that when you are in possession of a document that you decide not to turn over because you weren't going to use, it doesn't mean that it's not a discovery violation. I mean, they did use it. They didn't use the physical document, but they used the information in there. That's where the state has a problem. I don't want to get on my high horse, Judge. I'm not going to belabor the fact because the court's spot on in its insight with respect to everything that it said this morning. But as someone who's been with the prosecutor's office for almost 23 years, especially in the last few years, I've had to sit back on cases that were not mine, some of which I then had to get involved in, where the prosecutor's office was being accused ad nauseum of these heinous discovery violations, when in effect, a lot of times it was essentially some sort of minor oversight, clerical error, but yet in the press, the state and the prosecutor's office was looking like the demon, the villain.
State, again, you had me until you brought like I feel like I was victimized because, like, in the press, people were mean about the DA's office. You're a public facing figure. I don't know if you didn't realize this from middle school, because I figured everyone had a craptastic middle school, but there is a singular truth in life that not everyone's going to like you. You could be Mother Teresa, although apparently she might have links to that creepy guy who didn't unalive himself with that island. But a sainted figure. You could be, Jesus himself, and there would still be something that someone would be pissed off about. It is what it is. You know what I don't want to hear about? You whining about it right now. Just like I don't want to hear about Kim K explaining to me about why her astronomer said she couldn't do her homework. I don't want to hear you bitching about the media. As far as I'm concerned, the government and the media are two cancers on, well, the soul of humanity that maybe were fit for purpose at one point, but have mutated into a gross cancerous malignancy that is going to lead us to ruin. So I really just don't want to hear you whining.
To this court that over the course of the last 7 years, this office, myself, Ms. Wallace, paralegal team, our clerical staff have done everything possible to make arrangements to provide discovery to the defense. I've been personally, not by these attorneys, personally had my credibility tarnished, or attempted to be tarnished by.
Okay, like these two attorneys could tarnish anyone. I mean, at this point, let me find it, because we are going to play Clips game. We are woefully behind. Where is it? All right, I'm getting to it. Give me a second. At this point, we would all be better if this actually is a better legal argument than whatever's going to come out of Kim K's mouth. So before we have to listen to stupid, let's hear a good legal argument.
People versus Alfalfa Switzer. Criminal case number 1. Mr. Prosecutor, you are accused of burning down the clubhouse because you violated the #1 and only rule of the He-Man Woman Haters Club. No girls allowed.
If Alfalfa becomes the sovereign citizen, well, seems to me here, pal, that there was an Admiralty flag in here somewhere, and I don't believe you have served in the Navy. We are remaking The Little Rascals, the Sovereign Citizen edition.
I think I'm guilty. How do you plead? Like this? Please, oh, please have mercy.
Paul, look, I would never want you, and I use this word purposely, to taint Little Rascals, but at this point, this is your Hail Mary. Not that it's going to work, but this is what you need to do. Just plead like that. I need you to just not be.
Prior attorney for Mr. Caneiro, wherein I had to write a very scathing letter pointing out that in fact we did not have something at a certain point that we were accused of having and not providing. We provided discovery. It's been gone over ad nauseum by Your Honor, by Judge Oxley, every status conference. Is there any other discovery? We've done everything we can. I'm not trying to make this more than it is, but I think based upon the submission that we've received from the defense, certain things are clear with respect to what they had. And I would submit to the court, as I stated, that I don't believe that the New Jersey Supreme Court in tier intended for their opinion to mean that, hey, let's not document it because then we don't have to turn it over. I don't believe that's consistent with the language about encouraging practitioners to participate in cooperative discovery, etc. It's pretty clear what we have here. It's a clear situation. The court's insight is spot on with respect to the Susan and Katie and Marissa. You know, a lot of what Ms. Mastalone said is accurate. We did make attempts, and just because we didn't, Detective Petruzzello or Detective Weisbrot didn't document every effort over the course of the last 7 years to make contact with the family, doesn't mean it didn't happen. They know it happened. We tried our best to not harass them, certainly, but we had made efforts. Ultimately, it culminated with, we were supposed to meet with them on the Friday before the first trial date in September, and it was canceled because we were here arguing whether or not Mr. Canerio would be released. Then, prior to trial, we made efforts again. I did speak to Ms. Mastalone about it.
So basically, Miss Mastalone is operating under the understanding that a certain Supreme Court ruling in sort of the reciprocality of discovery between the defense and the state basically indicated that if things were written down, if there was like a report written or something like that, and we saw this used very effectively in the Karen Reed trial, where the witnesses for the defense, the expert witnesses, wrote very scanty reports, so they didn't have to really give all of the information that they were going to talk about to give the state time to prepare better. So it can be sort of a tactic, but the state is kind of accusing Kim K of using it rather cynically. So her basic excuse for every kind of little bombshell piece of evidence that she would try to bring in was that according to this new rule, I don't have to tell you anything. If I didn't write it down, I don't have to tell you anything. And again, yes and no. If you knew that this witness was going to bring in new evidence, you should have, for ethics, for everything to go smoothly, they should have allowed, again, usually you are deposed before some of these, things like that. Generally, the state gets asked questions too. That's how, they go back and impeach and see if your story's changed. Well, because Miss Mastalone kind of indicated that, we're not going to be calling the family. None of this is going to be coming in. And then all of a sudden in their state or in their case in chief, she's like, we're actually going to call them. And, by the way, we have this, never before kind of proffered or even forementioned kind of evidence in, and we're going to say that it proves this without any foundation. So there's a lot of things wrong with this, but it is sort of an advantage for the defense because the state has the burden and, the defense is allowed to do certain things and they're not under the same constraints. But the way the defense has used it here is incredibly cynical and probably not within the actual writing or intent of the law. While it might be, again, technically okay, it's not under the spirit or intent of the statute or the ruling of the Supreme Court in that state.
Said that she was in contact with them and would tell them to give us a call. Ultimately, Ms. Caneiro called Ms. Wallace back and indicated that she didn't feel comfortable talking to us. So they were on our witness list, yes, but as the court properly noted, that we can't put witnesses on the stand when we don't know what they're going to say, i.e. exactly what happened yesterday. This is not information that was provided to us. It was not known to us. We would have objected to the first part of the testimony yesterday had we known it was coming out, which we did not, obviously. And then, obviously, it became clear with respect to the iPad location and that clarification that she saw it in February of 2019 does nothing to clarify to this jury when that iPad was taken by Paul Caneiro or his wife or whomever who actually had control of the property after the scene was released by virtue of the executive status. That being said, Judge, I'm not going to believe this anymore. It's clear exactly what we have here. It was a document, it was not provided, and there's other information.
Let me ask you this question. If the court felt compelled that it had to allow some of this information, even if I do find a discovery violation, I just want to know the state's position as it relates to a need for time to investigate some of this information that you're literally learning 5.5 weeks into a trial.
Chase, the testimony yesterday that all of a sudden she looked at a text message and said read without the document. I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
Yeah, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Because I worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know. No time is going to allow me to figure out how that became read.
Yeah, basically, they have laid no foundation. Now, I'm not a lawyer if you're just popping in, but they have laid no foundation to prove that this is actually something that she didn't make up in Adobe Art or whatever. I mean, again, there is no authentication. There is no foundation that says, yes, we can prove due to, phone records and things like that this is in fact Jesse or, Jennifer Caneiro's phone being manipulated.
It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Walls would disagree with me.
I don't believe so.
It's going to do anything at this point in time. It's not going to allow me. I know I can find out when Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message after the fact. It's just that document is just clearly inadmissible. Whether the court ultimately tells the jury to disregard the testimony about it, that would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Massalone, would you agree with me that the document, the screenshot that you had, was an electronically stored document within Katie's phone?
The document that I had, Judge, was simply a screenshot of what she observed in live time.
Jesus, Mary and Joseph. Yes. Then she screenshotted it and kept it in a file of photos on her phone. Oh God, I'm not going to be able to handle this, am I?
Question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discussion.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes. Is it electronically stored? As far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it. According to you, the day before, so you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time. And in live time,
Wait a minute. Again, this makes Katie look so much more trash. I don't think they understand this because they're not they're very first order thinkers, so very much the priority thing at the moment, but they don't see how this again, so this proves that Katie, regardless of any maybe possible bend that she would have to exonerate her father, she sat on what she assumed was evidence that her other uncle was completely, involved in this, and you sat on it for 6 years. You let your dad waste away in jail because you were so pissed off with the state, you couldn't even go to your defense attorney or whoever was your dad's defense attorney and say, "Hey, I have this thing where Corey has the iPad really suspiciously close to right after. It struck me as weird, and this thing from Jennifer said red. Uh, you know, do you not understand how terrible this is making you look?" Again, to most first order thinkers, and I'm not trying to be disrespectful, but they just, as you dig more into it, it's worse and worse. If you are a surface level thinker, then she is an okay lawyer, and that's okay, but she's so bad.
says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it, but I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all.
So you justified the fact that you didn't tell them because you're like, I was being strategery. Oh my, ow. She makes the acolyte look like Shakespeare. The power of one, the power of two, the power of many morons. With their brain cells combined, Captain Moron is created.
I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So yeah, you did have time. You absolutely had time to turn it over. And it's not a fleeting moment. You knew with other text messages that you had.
Okay, to be fair, Judge, a fleeting moment, like when she has an epiphany, it takes about 4 hours. Let's be real. That light bulb only, very slowly lights up. It's not like a light bulb like when they show in cartoons that you've had an epiphany. No, that is a dimmer switch and it is on slow. Okay, so maybe for her, an epiphany takes 5 to 6 hours. She should go see a doctor after 4, though. Poor thing.
Where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. Tier says one thing, it does. But Tier does not mention, and it does not deal with the fact when something, it's not created by you. No one's asking you to create anything in this case. It already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This in this court's opinion aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly in this court's opinion is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it and you didn't turn it over. So if your answer is anything other than when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Kim K, I hesitate, but for the love of God, girlfriend, look, as I don't want to see, look, this is like a fight between a kitten and a werewolf. It's painful. Like a really dumb kitten. No, you know what it is? It's a fight between Hey the chicken from Moana, the chicken that eats rocks, and a leopard. And it's kind of painful to watch. It's like, oh God, someone help that poor special needs chicken. And it's kind of, look, I'm not rooting for you, but I just don't want to see Hey slaughtered, okay? Like, I enjoy a little schadenfreude, but I feel like I'm gonna need to call the burn unit after this. So I'll have some Alla ready for you.
Judge, I frankly, I don't know. I don't think it's clear. Again, my interpretation.
By Wolfram, apparently it's unclear that a screenshot stored on her phone could be considered an electronic record. Oh God. Ma'am, he is trying to... All right, you're on your own. Get your popcorn, y'all. It's going to be epic. Let's go. I'm done trying to protect her. Let's go.
Of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I
do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in...
Hail to the judge, he's the judge, and he is happy to yell his way. Like, Thank you, Judge. Thank you for being our human avatar of the rage at incompetence, because it's gotten to a point like her being a dingbat once in a while would be humorous, would be entertaining. But now it is actually kind of disrespectful to anyone who calls themselves a lawyer, because these two are are already damaging. People don't tend to have the greatest opinion of lawyers, but generally they think that they are at least competent. You are compounding sleazy with stupid.
You're in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance. So the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this.
The power of Hank compels you. The power of Hank compels you. Mr. Mo said he was going to throw away the Hank head if I didn't use it, so I'm oddly proud of it. I am not going to lie. Look, I wasted 3 hours staring at Hank Brennan, getting his bald spot just right. I am never getting rid of this.
I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019.
Oh, hell no, ma'am. Look, I have been the mother of 3 beautiful teenage girls. But what I can tell you is, do you want to understand what will piss off a person who has had teenagers? Off to the point that they will want to Will Smith you, and it's not our fault. It is a natural parental kind of response to some little teenage person who hadn't experienced life at all tries to roll your eyes when you are trying to drop some wisdom on you. Now, I can tell you that I don't lay hands on my children, but the eye roll is like instinctively my ancestors, like I was reaching for a slipper and I have never in my life thrown a sandal, and I was like, I'm gonna get a chancla. I'm telling you, the one thing that will make me lose my temper quicker and faster than anything else is blatant disrespect. You don't have to agree with me. I am not a dictator. You can think I am full of crap, but you at least give me the respect as the mother of the house. That you will not openly. You can disagree. I will have a passionate debate with you. If you say, hey, I'm a little bit irritated, can we talk about this in 10 minutes so I can cool down? I will give you that. What I will not have is someone under my roof disrespect me like that. And the judge is going to be like that. And I'm telling you, I'm telling you, this judge has had a teenage child, and his arm is pulling up, or he is going for a chancla.
The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly
To be very fair, Judge, that would be a use of logic and deductive reasoning. And let's be real, Kim K has never had a deductive thought or been able to extrapolate a hypothesis from random and various points of data. So you are just asking her to do something she's never been able to do. All right, I'm actually going to go on break now.
what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using.
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate, to refresh her recollection, would have been what you had in your possession, which was the screenshot, which included underneath the word red, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as.
Yeah, no shit, because you are being oh my God, what the fuck is this? This is not the CW, ma'am. This is not Hollywood. This is real life. I don't give a shit what his words are making you feel. And you should ask for a refund if this, whatever college you went to, told you that your feelings fucking matter in the real world. You are defending a man against a quadruple murder. Now, I generally respect most defense attorneys because they are there to, make sure that the system works, make sure that the awesome power of the state is not used to, curtail our rights, to take freedom away from someone. But you have approached this case with less seriousness than I do with. That's the thing. I actually put pride in my channel. I actually put a lot of thought in my channel. You are putting less thought into this than making Easy Mac. And you don't get why the judge is beyond disgusted at your disrespect for not only your profession, but what your profession actually represents. The stalwart defense against an overbearing state, the, protection and veneration of our individual rights. That's what your job is supposed to mean. Now, you might not take it seriously, but I guarantee you that most people do. Most people that are in your profession. So, yeah, finally, Judge. Jesus Christ, let's go back a little bit. You're using like big words. Oh my God, this is the best thing I've ever seen.
The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Miss Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you.
Oh, fuck no. She did not roll her fucking eyes at the someone better get an ambulance, because I'm telling, holy shit.
You just did. But the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to.
Oh my God, she's engaged? Who the hell is going to marry this bitch? I hope you're okay with her technically cheating and technically like breaking your budget. And whenever she feels, the need to do something, she will find a way to justify it. So I hope you're ready for that, because if she'll do it in her professional life, she's sure as shit doing it in her private life. This might be why she was drawn to Paul as a client. Howdy, howdy. Nefarious Shenanigans, duh. I love the name.
Further my position that that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise...
Wait a minute. Is now her argument that I am too stupid to have done this with malice? Like, I didn't do this intentionally. Is now your defense that not only is your client not too stupid to have done this, but you are too stupid to have made this mistake? Because I'm just not sure that's gonna... Ma'am, you are going to be lucky if after this case you get a guest spot as a bailiff on the People's Court.
The court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to...
Because you're functionally retarded and maybe other judges just give up. You have worn down the souls of other judges with your stupidity, and you've finally met one that just will not deal with it. Maybe other judges just let you get on because they understand that arguing with you like this leads you to talk about like my feelings, and it feels like you're trying to hurt my feelings, and they've just given up. But you've met a new judge, a new sheriff's in town, sweetheart. And he's a bit like, Bronson with his Webley.
Make sure that it's okay to ask certain questions, as I did before Katie Caneiro's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was...
Wait, you didn't see something coming because you couldn't actually perceive that there might be danger? Yeah, again, the I'm a moron defense. Great job.
There's a 25-page ex parte letter that pertains to Corey Caneiro. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post behavior by Corey and or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't...
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, it's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking.
Okay, MLS, I do see I see your post. She is doing nothing wrong, and if she did, the judge should never talk to an attorney like that. If this were a normal case, I would say yes. If he hadn't been dealing with weaponized levels of incompetence, it would be different. This judge has been incredibly lenient, especially with this defense going into areas that he's already ruled on and then acting like she didn't know. She has been incredibly ill-prepared and just very dismissive, very disrespectful, not holding up her end of professionalism. So while I understand that decorum-wise, the judge should not raise his voice, he has been tested mightily, and as a non-lawful law attorney, I am on his side completely.
The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes.
The
exactly.
reality is this: it goes to his behavior. It doesn't go to the fact of something that happens in 2020, a contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence
And wife duck, sorry. I will say that Law and Crime has christened her Snooki. I just thought that was too easy, and she very much reminded me of Kim Kardashian attempting to have a coherent legal thought. Now, I do think that Kim Kardashian will be able to do it one day. I think everyone's capable of learning. I'm not so sure about this defense attorney until she turns off her ego.
this is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is
Who
testimony.
testified to that? Who testified to Elisa going into the house and getting stuff out?
Oh, Ponytail does not want to be brought into this.
Judge, could I just?
It might have been a mix between Petrozello and Detective Vogt.
I think there
Who
was.
specifically testified that people went in the house, that they saw them go in the house and take stuff out, or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no.
You know what I'm asking you. It's not. We're not talking about AIG. We're talking about the fact. What's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
Buffering.
I don't.
Buffering.
I don't specifically. I don't have a recollection of exactly where that came in the trial.
Okay.
I know I didn't. I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure. I know it's a fact we knew. I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case. But number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission, because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not saying that I'm right.
Oh no, Judge Ken, your notes are right, sir. You done corrected everyone about the 0.0456 of sub elements of exhibits. So, no, this defense is actually illustrating very much the problem with true crimers transitioning into trials. So, and I see this a lot on big cases that have been going on for a while, or in kind of like this one. Uh, a person on the true crime side will have consumed every single backstory, every single thing that's hearsay, that's not going to be admissible, that is, a story from a friend of a friend who looked at Google Maps and did some interpolating and came up with this thing. The defense is fundamentally misunderstanding what they can bring into trial, very much like true crimers fundamentally sometimes maybe get confused, or because they're new to trials, don't quite get that certain evidence is not going to be allowed. Someone telling someone a story about what they could have saw is not considered evidence in a trial. And I can imagine that it's very frustrating when you come from the true crime world to come to a trial and be a little bit confused why aren't they bringing up this or this? So I do try to, I don't always pause because I have a squirrel. I do try to explain to people that are new to trials kind of what things are going on, because it is a bit of a hard thing. And I did have that sort of transition as well when I started watching trials, from going to that to people that were like looking at Reddit for evidence. So it is a bit of a thing, but it is a very clear illustration of the gap of understanding between kind of how true crime handles these cases and how maybe a more trial commentary case or person would handle these cases.
That's why I'm asking these questions, because I don't think it exists, and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony. And I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible, piece of information, I don't know. It was in the discovery, and they don't have the iPad. So, from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutors, is there something you want to say before?
Judge, I just want to clarify something. Really, is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire. That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who, went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds at school. So that's just to close the record in that regard.
I'll be back.
Ma'am, you decided to bring middle school rumors to the courthouse. Wow. You know, I actually have to hand it to you. Just when I think you can't be more ridiculous, you limbo right under my expectations. Ma'am, bless you.
Let's not bring up the jurors yet.
Oh God, he says, let's not bring up the jurors yet. Oh God. All right. Okay. It still looks like we are. Oh, here we go. Okay.
It was an issue before the court yesterday, but the court summarized earlier in oral argument, but did not render a decision on the admissibility of the evidence when it was brought up at sidebar. Instead, the court expressed concern that the information, having not been previously disclosed to the state, potentially constituted a discovery violation. The court directed.
This is after a break. We are significantly behind, though it does look like there's a fair bit of motioning and a break. Another sidebar. So we might actually catch up just because it looks like there are significant, we're going to get this and then sidebars and other things. So I am going to play the court while I get a drink because I forgot to get one.
Both parties to submit written memorandum addressing both the admissibility of the evidence and the discovery issue. After reviewing now the written submissions from the state and from the defense, and also listening to arguments this morning and a review of the applicable case law, court will render its decision now. First, I want to start with the premise under State versus Knight 256 NJ 404 2024, quoting State versus Williams 80 New Jersey 472, 478 1979. Quote, the thrust behind the reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. With that being said, and looking at our New Jersey court rule 3:13-3B2B requires the defendant to provide to the state, quote, any relevant books, papers, documents, electronically stored information, and any other data or data compilations stored in any medium from or through which information can be obtained. The phrase electronically stored information is broad and encompassing a wide range of digital evidence, but it includes and is not limited to text messages, emails, photos, videos, location data, metadata, and other information stored in electronic form. Rule 3:13-3F provides remedies when a party fails to comply with discovery obligations. The rule states, quote, if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with this rule, the court may order the party to provide the discovery, grant a continuance or delay during the trial, prohibit the party from introducing in evidence or material not disclosed, or enter such other order as it's deemed appropriate, end quote. Critically, Rule 3:13-3F also imposes a, quote, continuing duty to provide discovery, end quote. In other words, discovery obligations do not end when initial discovery exchanges are completed. If a party learns of additional discoverable material at any point during the proceedings, including during trial, the party has an immediate obligation to disclose that material to the opposing party. In this case, the defense has relied on State versus Tier, where the Supreme Court held that Rule 3:13-3 does not require defendant to generate a written witness statement where none exists. That's Tier at 228, NJ at 568. Tier protects attorney work product, specifically written summaries or notes that defense counsel creates during the investigation.
So again, we saw this used very strategically in the Karen Reed case. There were certain expert witnesses that the defense didn't have them write a very long report. So this can be done with more strategy and without breaking the rules. There are ways to do this to be strategic, to, again, advocate zealously but not break the rules. And we've seen it before, so it really is ridiculous that she's trying to pull this. I didn't write it down, so technically I can bring it up.
The court in Tier emphasized that that compelling defense to create statements would invade the attorney-client relationship, reveal defense strategy and theory, and violate the defendant's Sixth Amendment right to counsel. The court did not address and specifically did not decide what obligation a defendant has with respect to independently created physical or electronic evidence that exists separate and apart from any work product created by defense counsel. In Knight, the Supreme Court addressed a question Tier did not resolve. What happens when independently created physical evidence exists and defense has access to it? There, the court held that an affidavit not created by defense counsel must be disclosed under Rule 3:13-3B2B. The court indicated, quote, the affidavit is physical evidence of a crime. It's not the product of the defense investigation or attorney work product. Rather, the affidavit is a relevant writing, potentially in defense counsel's possession, pursuant to Rule 3:13-3B2B. There is no question that this type of physical evidence falls squarely within the defendant's required reciprocal discovery obligations. That's Knight 256 NJ 404,422 2014. The court distinguished previous cases before the court in State versus Mingo and State versus Williams of turning over inculpatory evidence. The court in Knight also rejected Sixth Amendment concerns. Quote, no such concern is present in this case, however, in which the item in question is physical evidence and not the product of defense counsel's investigations. That's Knight at 423. Significantly, Knight uses the phrase, quote, potentially in defense counsel's possession rather than actually in defense counsel's physical possession. In this case, we know that defense counsel physically had possession of a screenshot of a communication between Caitlin Caneiro and Jennifer Caneiro, where the document specifically shows that at some point in time, the text message was read. That item was never turned over to the state at any point in time until well after the testimony. The court now applies this legal framework to the two pieces of electronic evidence at issue in this case, beginning with the text message screenshot. Here, the text message screenshot depicts electronic metadata showing that a message sent by Katie to Jennifer now displays a status of, quote, read, end quote. First, as to the origin of the screenshot, the, quote, read, end quote status was created by the iPhone messaging system, not by defense counsel. When Jennifer Canero's phone or other device logged into her iMessage account, opened Katie's message, the messaging system automatically generated the, quote, read, end quote status and transmitted that information back to Katie's device. This is a function of how the iPhone iMessage system operates. It's not something that defense counsel created, directed, or had any role in producing. Similarly, the screenshot itself was created by Katie Caneiro, not by defense counsel. Katie took the screenshot on her own phone and then transmitted it to defense counsel. Under Knight, this electronic evidence, quote, falls squarely within defendant's required reciprocal discovery obligations, end quote, because it is, quote, not the product of defense investigation or attorney work product, end quote. Second, as to the discoverability, the text message screenshot unquestionably qualifies as electronic stored information. It is a digital image file depicting electronic metadata from an iPhone messaging application. It is stored on Katie's phone and was transmitted electronically to defense counsel's phone or computer. This is precisely the type of electronic evidence that Rule 3:13-3B2B contemplates. Moreover, defense counsel actually received that screenshot on February 8th, 2026, according to defense counsel. Defense counsel had that screenshot in her possession when Katie testified on February 9th, 2026. Thus, defense counsel had actual physical possession of the electronic file. The fact that defense counsel chose not to introduce the screenshot as an exhibit at trial does not change the discovery obligation. Defense counsel's strategic decision about how to use the evidence, whether to present it through testimony describing it or through introduction of the exhibit itself, does not eliminate the requirement to disclose it to the state. It's discovery rule 3:13-3B2B. Finally, the defendant's argument assuaging noncompliance are unavailing. Under Rule 3:13-3F, there is a continuing duty to provide discovery. The fact that the defense counsel received the screenshot only one day before Katie was scheduled to testify, according to what she has said, does not excuse the failure to disclose. Further, the defense's reliance on TIER misunderstands the distinction between TIER and Knight. TIER protects defense counsel from being compelled to create written summaries or oral written statements. TIER does not protect defense from disclosing independently created evidence that defense has the ability to obtain and had it in her possession. Because the screenshot was created by Katie and the messaging system, not by defense counsel, Knight requires disclosure regardless of whether defense counsel ultimately introduces it as an exhibit. Therefore, this court finds that defendant violated its discovery rule obligations as it relates to the text message read status of the text message between Katie Caneiro and Jennifer Caneiro. As to the GPS, the iPad location data was created by a location sharing service or application, not by defense counsel. While the parties have not identified the specific service Katie used, common location sharing services include Find My Phone by Apple, Life 360, Google location services, and similar applications. These services use GPS technology to track the location of devices and share that location information with authorized users. When Jesse Canero's iPad shared its location with Katie's device, the location sharing service generated GPS coordinates, timestamps, and other metadata showing where the iPad was located at various times. This data was created by the technology, not by Defense Counsel. Defense Counsel played no role whatsoever in the genesis of this electronic evidence that was created by
Genesis, both the Phil Collin and Peter Gabriel band would like to be left the hell out of this. Also, the first book in the Bible would like to be left out of this.
The witness's actual iPhone. First, location sharing data is unquestionably electronically stored information within the meaning of Rule 3:13-3B2B. The rule specifically requires disclosure of electronically stored information and any other data or data compilations stored in any medium. Defense Counsel states that the defense simply has what was verbally relayed during a recent witness prep session. However, the test under Knight is not limited to evidence that Defense Counsel has already obtained and is physically holding. Knight uses the phrase, quote, potentially in Defense Counsel's possession, end quote, indicating the test extends to evidence that the Defense Counsel has the ability to obtain. Defense Counsel argues that Tier protects Katie's testimony about what she observed because Defense Counsel has no written statement or document to turn over. Defense Counsel contends that Katie simply told counsel orally what she saw, and Tier holds that Defense Counsel need not create a written summary of the oral statement. This argument fails for the same reason it fails with respect to the text message screenshot. The issue is not whether Defense Counsel must create new work product summarizing what Katie said. The issue is whether Defense Counsel must obtain and disclose independently created electronic evidence that exists separate and apart from any work product, or at least to ask about it. Caitlin Caneiro did not merely remember seeing something. Katie used a location sharing service that generated electronic data. That data exists or existed in electronic form. It was created by technology, not by Defense Counsel. If Defense Counsel had the ability to obtain the data from Katie, then Defense Counsel should have requested it, or at least indicated to the state that it does not exist. Tier protects, as I indicated, work product created by Defense Counsel. Tier does not protect Defense Counsel from the obligation to obtain and disclose independently created electronic evidence within Defense Counsel's control. I should also point out, as it relates to the location sharing, that Defense Counsel indicates in a footnote on page 2 of her brief that she must have learned through her conversation. I'll just use her words. It should be noted that Defense Counsel further recalls the witness mentioning that she confronted Corey about it, either via text message or phone call, once she saw that she had the location, and asked him why he taken Jesse's iPad. Why he had taken is probably what she meant to say. Corey then turned off the location. However, so in that circumstance, that is more information that if the state had that information in advance, would have had the opportunity to actually investigate whether that phone call or text message actually existed, had the opportunity to reach out to Corey Caneiro, and if they wanted to or so choose to figure out if that existed, to get other phone records in this particular case, which at some point they did not feel that they needed at the time that they originally interviewed her.
And that's the big problem. The state might have, again, partially made their choice not to call Corey because they were unaware that, because they hadn't talked to Paul's family didn't really talk to them, that this information was out there. So again, they were kind of playing with a not all the cards on the table. And it's just, ugh, gross.
What happened here is that defense counsel put the state in a position by not providing any information as it relates to that metadata for the location services. Puts the state in a position where they did not have the opportunity to even investigate, which is exactly what I said from the beginning, that State versus Knight talks about, that the thrust behind reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. Okay. So, with that being said, defense counsel devotes substantial portions of the written submission to arguing that Katie Caneiro was available to the state for more than 6 years, and that if the state wanted to learn about the evidence, the state could have re-interviewed Katie at any time. This argument fails to excuse the discovery violation for several independent reasons. Number one, the discovery obligations are independent of the state's investigation. Under Rule 3:13-3B, it imposes discovery obligations on the defense that exist independently of what investigative steps the state has or has not taken.
And the problem is that it can be used very strategically, and I don't have a problem with people being very strategic. Part of the really interesting thing about trials is seeing all the various ways that people deal with bad facts, both the state and the defense. And sometimes there are very, very good attorneys that can, create a strategy that really mitigates bad facts, or and that's interesting to me. What is not interesting to me is trying to get cheap points, trying to do something sneaky and thinking it's clever. And it's most certainly isn't. Again, there were certain points for this case that I think the defense had. Again, in my estimation, it was going to be more of holding the state to its burden. But there were some things that I think they could have brought out. It was still probably going to be an uphill battle of Sisyphean proportions, but there you go. That being said, to do something kind of sneaky and cheap like this means that you don't really, have confidence in your case. And I get it. We've seen the evidence.
This rule does not contain an exception stating that a defendant need not disclose evidence if the state theoretically could have discovered it through independent investigation. If defense counsel's argument were accepted, it would eviscerate the reciprocal discovery rule. Under defense counsel's theory, a defendant would never have to have a discovery obligation with respect to any evidence that the state could have found on its own through a diligent investigation. This would include written statements, documents, physical evidence, and electronic data. The defendant could simply wait to see what the state discovers and then spring any additional physical evidence or electronic data, arguing that the state should have investigated more thoroughly. Second, the evidence did not exist when the state interviewed Katie. Defense counsel argument in that area also fails. The state interviewed Katie Caneiro on November 20th, 2018, the day after the murders. At that time, the text message did not yet display a read status because Katie had not yet checked it after Jennifer's death. At the time, Katie had not yet tracked the iPad location of Corey's residence because it did not occur until February 2019, several months later. The state cannot be faulted for failing to ask Katie about evidence that did not yet exist at the time of the interview. The notion that the state should have conducted follow-up interviews with Katie every few months for the next 6 years on the speculation that she might someday check our old text messages, track an iPad location is unreasonable, and this court finds no support in law. Defense counsel argues, as a third point, that it would be unfair to penalize the defense for recently learning information that the state could have discovered years ago. This argument actually supports the state's position rather than the defendant's position. If the timing
Oh, don't you hate it when your own argument is actually for the state? Again, you should run these by like ChatGPT, Obi-Wan Kenobi, a Furby at this point, one of them magic 8 balls, a D20. I mean, at any point, whatever spin the wheel, pick a choice you're using is not doing very good.
of when parties learn information matters for purposes of fairness, then the relevant comparison is not between when the state first interviewed Katie in 2018 and when the defense counsel interviewed Katie in 2026. The relevant comparison is between when defense counsel learned about this evidence and when the state learned about it. Defense counsel learned about the iPad location on either January 30th, 2026 or February 8th, 2026, based upon defense counsel indicating that she had prepped Katie Caneiro for the first times for her testimony on these two particular dates. Defense counsel obtained the text message screenshot on February 8th, 2026. Katie testified on February 9th, 2026. Defense counsel had somewhere between 1 day and 10 days to disclose not just the evidence for the text message, but also the iPad location information so that the state could have had the opportunity to take a look at it and investigate it. The state has literally had zero time to investigate any part of this information, to verify it, to contradict it, to subpoena for more information or anything in that matter. If fairness and timing matters, as defense counsel argues they do, then the fair result is to give the state the same opportunity to investigate that defense counsel had. That is precisely why the continuance would be accomplished if it was requested by the state. There are questions here that the state cannot answer simply through cross-examination of Katie Caneiro. These questions potentially require investigation, consultation with technical reports, forensic evidence of Katie's phone, review of service provider records, and potentially interviews of other witnesses, including Corey Caneiro himself. The state cannot conduct this investigation while Katie is on the witness stand testifying before the jury. The state would need time to investigate before the evidence impacts jury deliberations. The state has indicated before they heard my decision that they would that they did not want a continuance for any reason. However, before I finish this opinion, I'm going to give them the opportunity after hearing the opinion to make any decision that they would like to make. The court is relying on 3:13-3F, where the trial court is afforded wide latitude to resolve discovery disputes. Moreover, in appropriate circumstances, the court can either order discovery of items beyond the scope of the discovery listed in Rule 3:13-3. However, in this case, under the circumstances, the court is not going to use the draconian remedy of actually barring some of this evidence, and I'll go through it in a minute, but the court would consider a continuance for the state if they needed more time to look at this. However, let me say this. As it relates for the rationale behind the reasoning for the GPS testimony, which
See, I don't think the defense anticipated that they were opening Katie up to intense scrutiny of her own phone records. Again, this is that single layer thinking that doesn't think several steps ahead. You are in an adversarial process. You should think, if I do this, my opponent's going to do this. This is very much like verbal chess. You have to be able to, on your feet, think of several different ways that your argument might be attacked. So this is very clunky. I've never seen kind of a lawyer that misses the point of what lawyering is so much.
The defense says this testimony is relevant because, and this is relating to the GPS location of where Jesse's iPad was located for two reasons. One, it demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross.
CCR would like to be left out of this too. There's a bad mood arising, and, well, it's this defense.
Examination of Detective Votes, cross-examination of the Detective Vote.
My apologies, that was the third time.
Can we go off the record for a second?
Judge, off. Why?
What was going on? No. Interesting. Seems like an odd courtroom to just randomly wander in and disrupt.
Okay. For the record purposes, an individual was removed from the courtroom for reasons for the sheriff's department to take care of. I just want to go back and say for the two reasons why the defense believes that this is admissible. The GPS locations. It demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vogt regarding the Tiffany's jewelry boxes found on top of the fire rubble, both of which occurred prior to Vogt's collection of DNA samples in 2020. Second, that it demonstrates a failure to investigate for whatever reason. The police did not seize or search the iPad, but they did seize or search Sophia's phone. I will take them in order. As it relates to any type of Corey's taking of these items out of the house after the homicide, the court had rendered a decision on January 27th, 2026 in a 42-page opinion outlining what behavior that and what instances that would be allowed to be elicited.
Denise, it didn't look like a family member, to put it delicately. It almost looked like someone who had wandered into the wrong courtroom. It was kind of the vibe I got, but maybe it was a family member or friend.
By the defense of either Corey Caneiro or if there were certain other witnesses that took the stand as it related to Corey Caneiro. The court in that order court specifically said that it found as wholly inadmissible any alleged post-crime suspicious activity involving Elisa Caneiro and Corey Caneiro. In this circumstance, the allegation that Corey went into the home and took out the iPad allegedly, because at this point in time, there's testimony about a GPS location. I don't know if the state's going to end up asking for for a period of time to actually look at the witness's phone to find out if the GPS actually is there or not. But right now we only have testimony about that. And the reality is, I have no evidence in this case other than that at some point in time, potentially, Corey had Jesse's iPad. I was supplied in.
Mr. Mo, so I made a deal with Mr. Mo. To be fair, I have had a lot of different blankets. My leg doesn't tolerate a lot of, when I got the room redecorated, I wanted to have a really nice, like, grown-up comforter, but my leg can't tolerate, so I would end up sleeping on top of it, using light blankets. Well, he found one of the, giant fuzzy blankets. Huge. It's huge. So, I did promise that I would throw away all my other well, not throw away, but, Goodwill, that kind of thing. So, yay!
The submission by the defense, a photograph of the kitchen of Keith Canero's home that had an iPad there. That iPad, whether that's Jesse's or not, that's what is being offered by the defense, that it's Jesse's, and that Corey may have taken it. But Corey also was responsible for taking over everything after Keith and his entire family was obliterated from this planet, and Corey was left to handle all of the issues that were relating to the estate of this. So I can't find, under these circumstances, that Corey taking items from the house is relevant. I find that under 403 that it actually would be a confusing issue for the jury, because the probative value is significantly outweighed by the prejudicial effect of trying to understand first, was it Corey that actually took it out of the house? Was it somebody else that took it out of the house and gave it to Corey at some point in time?
I honestly don't think so, for the very reasons that the judge very reasonably put out, that would have a completely honest and, not nefarious reason for Corey to be touching, items after the scene was released. The defense is saying, oh my God, they didn't investigate him. With the security that they had around the crime scenes until they were released, no one was getting into those scenes to touch anything. So the defense has been using this evidence for a premise that isn't proven by the evidence. So I like the way the judge is completely obliterating them. Yes, and thank you for all these ideas of what to do with blankets, because I do have a hard time, getting rid of things if they could be used by someone who really needs them, or there are alternate uses. And doggo blankets might be good, because look, they've been in my house. I'd honestly probably be embarrassed to send them to Goodwill. So doggo blankets is a great idea, because they can be washed up. But youngest most feral likes to drink red Kool-Aid, and for some reason he just has to do it on my bed. I don't know why.
Was it, who knows? The answer is that no one knows that. There's no testimony to that. There's no connection that has been shown, at least at this point in time. So the fact that the allegation is that Corey took items out of that house is not something that this court finds that would overcome a 403 analysis. The second issue is one that's something that's more in line with what I can understand. The second issue deals with a failure to investigate, because the police did not seize and search the iPad while they did seize and search Sophia's phone. As it relates to what the investigation revealed and what it may not have, what they did and what they didn't do, that is relevant overall in this particular case. The issue in this case is whether there was other evidence in this case that would point to a different individual. other than Paul Caneiro, and the investigation and looking into other areas such as the iPad, I do find to be relevant. I do not find under 403 that its prejudicial effect would be outweighed by the probative value. So I am going to, for purposes of this testimony, I will allow the fact that the iPad has been, was taken out of the home. However, the testimony as it relates to the GPS location is something that I'm going to strike from the record. There is no relevance to that other than under 403 as an overall thing, that there would be a confusion, that the prejudicial effect because of that confusion outweighs any probative value. So we can handle that in one of a few ways. Number one, there can be an agreement that Jesse's iPad, that there can be a stipulation that Jesse's iPad was not searched, was not taken and or searched, or some other type of stipulation that you can come up with. But there will be no testimony as it relates to this iPad until someone can give me a proffer.
They are out of the presence of the jury. This is so basically the judge has listened to both arguments prior to taking kind of what he was going to do into account. Now that he has made a ruling that this is not good, he is going to give the state kind of an option like, okay, you guys can stipulate to the fact that Jesse Caneiro's iPad was not searched. You can ask for a continuance in order to get with your technology people and see if it was searched, if in fact it was searched and released. Because I have a really hard time thinking that this really, really good, thank you, investigation, the state's investigation would just ignore the hell out of an iPad that could have information on it. What they probably did was they searched through it, didn't see anything that was at all related to the case, and turned those over to the surviving family member who was taking care of his family's effects. I mean, I just think that had the state known all of this was coming in, would they have still brought in or still failed to call Corey? It would depend. I do wonder how much involvement Corey has had with the state. Maybe I'm wrong in assuming that Corey would want to talk to the state at all. Maybe he does have a bit of resentment for whatever reason over the state going after his brother. I don't know. So all of this is in the assumption that Corey maybe has been helping the state, and the state knows how hard this has been with all the accusations. It could be that they felt that they just on a base level had a good enough case. So I don't know. I guess I am making assumptions based on assumed continued involvement with Corey, at least on the state side. So maybe that would have changed if they knew what the defense had.
In advance of exactly what's going to be said about it. Defense counsel, out of fairness to the defense, offered up some suggestions. I'll leave it to the state and the defense if they want to come up with something that would be that they feel would be fair to both sides. However, the admissibility of the GPS location as it relates to the two reasons why that the defense wants to bring it in, the court does not find under those circumstances that it would allow the GPS location in. Again, it will allow the fact that the iPad was not seized or searched, but as it relates to GPS location, this court has difficulty with understanding how there is a connection between where the iPad was located, especially when the defense is specifically saying in their submission that they are not saying that the iPad was taken during the murders, that the iPad was located still at the house after the murders, that there's no connection to Corey Caneiro or third-party guilt as it relates to that particular iPad, that I do not find a connection there under Codaditch, and I would not allow that in for purposes of any third-party guilt. But like I said, I would consider it for purposes of a failure to investigate. As it relates to the text message, as I indicated, I'm going to ask the state now if the state would like some time to investigate and or whatever that they need to do. I would entertain that. If the state decided that they did not want time to investigate, I am going to give them latitude as to the cross-examination in this specific area of the witness as it relates to that screenshot and how it was provided, when it was provided, and how that all took place. So with that being said, that's the court's decision, that even though I do find discovery violations on both, I find that under these circumstances that the draconian remedy of excluding them for the reason of a discovery violation is not what this court is doing. However, in looking at the actual items, I have made rulings as it relates to my understanding of the evidence rules and how it should be allowed in or not allowed in. So with that being said, to the state, I'll give you the opportunity to let me know if you want what your preference is under the circumstances, and also if you want some time to speak to counsel as it relates to a stipulation as to the second part of Jesse's iPad.
Sure, Judge. I think Ms. Wallace is going to talk to Ms. Mastalone about the iPad. I'm going to go inquire. I highly doubt I'm going to ask for any more time other than 10 to 15 minutes just to think about it.
Okay.
The only question I had, Judge, with respect to clarification of the court's order, obviously they heard it was read, part of that testimony, but we got that document in the brief last night. Is the defense allowed to utilize the actual screenshot?
Well, let me ask you this question. Does the state, under the circumstances that it's been put in, would you want to use that on cross-examination and to go in the circumstances surrounding that testimony that you already have? Because as I indicated, I'm going to give some latitude because of the fact that I do find it is to be a violation, but I do find that under these circumstances that I'm going to allow it in because somebody opened it. It's already.
And as much as I wish that he would have blanketed said no, I do find that he is incredibly measured and thoughtful. And I like that about this judge. So even if my proclivity would be to, say, strike it, no, you're done with your shenanigans. I find this to have been willful and, very, very premeditated. He is able to shake off disrespect, shake off eye rolling, and then come back and really be a very, very measured, goalkeeper, allowing things to come in that, have been introduced, that the jury are going to ask questions about, giving the state wide latitude to kind of question information about this. Now, I do caution the state, maybe they know they already have this information, but hubris and thinking you have something in the bag is the quickest way to lose right at the end. So while everything inside of me is saying, oh my God, no, do not take a recess, do not drag this trial out any longer than necessary, my personality would be to take the recess, as much as it pains me, to actually do further research about the provenance of where the iPad was, what we did with it, what we took, what we didn't take, and have all of my answers down pat. So Now, that being said, I'm part very, very pragmatic and part impatient, so I understand the desire to, like, "We are this close to the end, and you want to do what?" So I get it. I get it, but I do worry that maybe the state is a little too overconfident. As I have said, I am willing to give the defense as much as I've made fun of them, I am always willing to, if you make a good point, call it out. And this might be the one time that the defense really has a good point. So I hope the state knows what they're doing.
Out there. And I don't think that I can clear that out of the jury's mind. And I think it's really at this point in time, the preference of the state. And again, if you want a few minutes to think about that, I'll give you the opportunity to do it. And again, if you need more time, then all you have to do is ask for that. And out of fairness, I would give you that opportunity to have more time. I don't want anyone, either side here, to sit here and worry about the trial and how long the trial is going or how quickly it's going. It's truly your own prerogative for the state, and you and Ms. Wallace should have the opportunity to think about it now that you have my decision.
Okay, Judge, yeah, I would just like a little bit of time to think about that.
Okay, why don't we meet back here at 10:45? I'll give you 30 minutes. If you need more time, you can let me know. We're going to tell the jurors downstairs we're in a little bit of a holding pattern, and I'll have Amor do that. I won't address them myself.
Okay, this is after 30 minutes. Oh, now they're going to a sidebar. The jury is so fucking pissed. I mean, the jury was looking at the glimmering, hopeful potentiality of getting closing statements at some point this week. Now, I really do wonder, after the sort of blow to the defense's confidence that today is, I do wonder if that is going to affect any strategy of having Paul go on the stand or not go on the stand. And it does seem like the judge is dealing with some sort of, at least, timeline or ticking time clock, because one of the juror or some of the juror members having plans that can't be moved, coming, I think, fairly soon. Again, while this was, because I did look at it and it was scheduled for a 5 to 6 week trial, the judge is maybe a little too optimistic, telling everyone that we're speeding through this trial when we're not. And the defense has really, I think, irritated the jury because they don't bring anything. I think the jury would be fine with long and extensive cross-examinations if they actually garnered anything. But instead, it's the same, like, 2 or 3 questions asked 15 different ways with buffering. Oh, so yesterday we finished with the DNA expert basically on cross admitting that while some of the samples did have a very small number for Paul, there were other samples taken from the genes that were clear and very definitive, as far as much as star mix can be definitive, that this is that Paul can be included, that his DNA profile was included in the mixture of his and Sophia's blood. Now, the defense expert went so far as to say that the reddish brown stains on the genes were possibly not blood. They were presumptively blood. But if he had remembered anything, there's a 2-step process by which the lab goes. They go presumptive blood, they send it off to DNA, they do a confirmatory test for blood. If that is positive, then they continue to do DNA. Now, if it's not positive, they do actually do a standard test run on that as well, just because it might not be enough blood to actually, turn the test, and they want to be thorough. So this is definitely something. All of this is dumb. Do, do, do. Okay, they all.
Sure. Sure.
Ladies and gentlemen, we're going to break to give the state a little bit more time. We'll start back up at 1:30.
Okay. So what I am going to do is end this stream. I am going to edit to come back at 1:30. So give us about 30 minutes because it's nearly 1 my time. So that way we can take a little break. I can get some food, which is apparently, one of those things I need to continue to remind myself to do. You guys can get a little bit of a break, and then we will be back to hear what the state did. Let's see if we can get a little, well, it looks like we are going to be, I was about to say they're not back yet, so we can't go forward. So anyway, I'm going to go for a little bit. I will see you in just a minute, and then I will update that time so we start at 1:30. And if you know someone who has a little bit of the dark humor and a whole lot of the snark and you think they'd like to watch trials, send out, share this, let people know, invite them to the Church of Mo. As long as they would get the joke. If they're going to call me in for starting a cult, just give them a thumbs up and don't invite. Bye, you guys.